Welcome to Property Angel Academy, Vijay, and thank you for joining us to talk about estate planning, which of course you have been doing for very many years with Prop Seva. So we wanted to just understand the basics first, right? Like what do we mean by an estate and what is estate planning?
At the outset, I would like to thank for the opportunity to educate your clients and prospects in general with reference to estate planning. The word estate, the generic meaning is, as understood by majority of the population, is coffee estate, tea estate, and like that the understanding goes. But in reality, estate means all your property, movable and immovable, investment in shares, debentures, mutual funds, your vehicles, gold jewelry, all put together is known as estate. It's not estate. And the planning is required. The planning is required because we all enjoy all these assets. One fine day we say goodbye to this world.
Yes.
And what happens? Who gets what and how? This is what estate planning is all about.
So it's all about really creating a will and structuring a will, right? So can you just help us understand what is the typical structure of a will, who and what is required to create a will?
Will is, what is will is the question now. Declaring my intention as how my entire estate or assets to be distributed to my legal heirs or the beneficiaries as per my wish after my death is what will is all about.
Yeah.
That means it is my intention or declaration.
Yes.
Putting on a paper. That's what will is all about. Now coming to the structure, what is that we need to put? Everyone says writing a will. How to write? What are the points to be considered?
Yes.
All these things need to be taken into consideration to be a valid will. Right?
Correct.
Now, as I told you, it is my intention. Right? One is intention. Now, identification of assets and declaration of that on the paper. Not only assets, but also debts, loan, etc. can also be mentioned in the will. Okay. Apart from that, how my medical expenses to be treated. In case a minor child were to be there, how he or she should be taken care of. All these things can be mentioned in the will. Okay. And how the transfer or bequeathment, that also can be mentioned with a valid signature of the person who writes the will, with two witnesses are required. These are all the requirements of the will.
Okay. And who can write a will? A lawyer is required to write a will, or who writes the will?
So, there is general understanding is lawyer writes the will. But even this person who knows to read and write, whether it is in English or in vernacular language, that is also permissible. Only thing is he should be very clear as far as declaring his intention, identification of assets, who should get what. All these things should be very clear. It can be mentioned in a simple language so that there is no much complexity in understanding this.
I see. You also mentioned that medical expenses can be mentioned in the will. Now, a will gets executed before, after somebody dies, right? So how does the concept of medical expenses come into the perspective of things?
Okay, there are one real life situation that let us take into consideration. See, I have an account. In my account, money is lying there. I have not dead, but I got into ICU, let's say.
Okay.
Now I cannot sign the check.
Yeah.
No. Who will draw the money?
Correct.
And it is not a joint account.
Okay.
Ha. Situations, real life situations, considering that, that also can be mentioned in the will. That's
I
what I
see.
mean by that.
I see. So, in that case, when is a good time to create a will?
At the moment a person accumulates the first property,
Hmm.
it is not the age.
Okay.
See, when it comes to question of insurance, the moment you start earning, you take insurance because your family is depending on you.
Yeah.
That's what we say.
Yeah. Yeah.
Now, in the same fashion, your family is depending on you. Something happens to you or a estate owner, how the entire things have to be transferred, how it has to be handled. All these things need to be considered. No? So, the moment you accumulate the first property,
Okay.
that is the one part. Second thing, a person who goes for a high-end car, let us say, maybe
Okay.
15, 20 lakhs or something like that.
Okay.
After he becomes the owner, suddenly he dies because of the heart attack, let us say. Who is the owner? Who is the owner next?
That's true. Yeah.
There are so many documentations to be provided to RTO. All these things could be avoided. That's all it is.
Yeah. So, what happens in this case? Let's say somebody dies and there's no will, right? What happens?
See, as far as the inheritance part is concerned, inheritance means transfer. There are two types of inheritances. One is testamentary, other one is intestate. In case of testamentary, there is a valid document which says who should get what, and it is legally accepted. It is known as testamentary succession document rather. So in case of intestate dying, there is no document as such.
Yeah.
It is here the succession laws come into existence.
Okay.
So in India, succession laws are based on religion.
Okay.
Hindu Succession Act is applicable to Hindus, Buddhists, Jain, and Sikh.
I see.
Indian Succession Act is applicable to Christian, Parsis, and Jews, and also interreligious marriages, which are registered under Special Marriages Act. All these things come under Indian Succession Act.
Right.
Muslim personal law is for Sharia law is applicable to Muslims.
Okay.
So it is very clearly been defined in law as how the bequeathment should take place.
Okay.
So there will be a lot of complexities in that to understand. So to avoid that, it is always better to execute a will.
Okay. And does a will have to be registered?
As per law, registration of will is not mandatory.
Okay. Okay. Okay.
But not registering, what are all the complications that arises, one need to keep in mind.
Okay.
The moment if there were to be a physical property, then the will is there, but it is not registered. The moment it is taken to the sub-registrar office, sub-registrar office will ask for a document.
Okay.
To prove that you are the legal heir and all. For that, you may have to get a family tree in Karnataka.
Oh.
So,
okay.
in the absence of registration and all, these problems are likely to. I am not saying that it is not a valid will, but from the government perspective, it is different.
Okay. Okay. And what is the process to register a will?
Go to a sub-registrar office. Say, person who writes the will and two witnesses, they have to go to sub-registrar office.
Okay.
Then there is a process, some fee has to be paid.
Okay.
Then the formality, they take the photograph of the person who wrote the will, who is known as testator, and the witnesses, everything will come in the backside of the will itself.
Okay.
Their photo will come.
Okay.
So that means it is a validly executed document.
Okay.
It is accepted by sub-registrar office. Okay. So it will have a more validity and strength. It will be more.
Got it.
It will be more stronger.
And the fees to be paid for this, is it dependent on the size of the estate? I mean,
No, no,
size
it
of
is
the
nothing.
value. Okay.
No, no, no. It is not based on the percentage of the property on the total value of the estate. No,
Okay.
it is not that way. It is not.
Okay. What about probate? Does every will have to be probated?
Yeah, a a copy of the will
Hmm.
is certified by a competent court.
Hmm.
That means they will fix a stamp. Court stamp will be there. So
Okay.
what they do is, say, a person who wrote the will is not in this world.
Hmm. Hmm.
Witnesses will be called.
Okay.
They will examine the validity of it.
Hmm.
Then they put a seal. Then it will become an evidentiary value.
Okay. Okay.
Evidentiary value. The
Okay.
will definitely gets evidentiary value.
Okay. Okay.
That is known as probate. That is known as probate.
Okay.
Now, probate is mandatory in Chennai, Mumbai, and Calcutta.
Hmm. Hmm. Hmm.
Other parts of India, it is not mandatory.
Okay. Okay. If it's not mandatory, what is the advantage of doing a probate in the other cities? Is there any advantage?
See, depending on the situation, maybe there may be a dispute in the family.
Hmm.
Then probate is needed.
Okay.
Okay. Under those circumstances, we can go to court and then see that to prove the validity of the will. Now,
Okay.
let me give an example.
Okay.
4 children are there.
Huh.
Father has executed a will,
Hmm.
let us say.
Hmm.
Now it is not registered. Now, 2 sons will say that the father was not in sound mind while executing the will.
Hmm.
There is an issue in the family, let us say.
Okay.
Under those circumstances, if they go to court,
Hmm.
court will call witnesses and then this process is known as probate. That's it. That is the advantage of it.
Okay. Even if the will is registered, this might happen.
Now, sometimes it may happen, depending on the situation.
Okay. Okay. And there are different types of wills, right? Conditional will and different types of wills. So can you talk a little
Yeah,
bit about the
yeah.
different types?
See, mainly there are two classifications are there as far as the will is concerned.
Hmm.
One is privileged will,
Hmm.
other one is unprivileged will.
Okay. Okay.
General public who are normal persons,
Hmm.
whoever executes, it is known as unprivileged will.
Hmm.
So privileged will means a person who is fighting in the war field,
Okay. I
like
see.
army, navy, air force,
Okay. Hmm.
those type of category people. No? They don't have time to write the will. They are
Yeah.
fighting in the
Yeah.
war field.
Yeah.
Those type of people are being given a privilege.
Hmm. Hmm. Hmm.
Even if they orally say to the friend or a fellow army person, stating that in case of my death,
Hmm.
my entire property should be transferred in this fashion. If he
Okay.
says orally,
Yeah.
and the friend comes and says that he said and died and
Hmm.
documents that, then it becomes a valid. So that is a
Okay.
privileged will. Only for a
Okay.
privileged class it is being given.
Hmm. Hmm. Hmm.
Coming to the conditional will which you asked,
Hmm.
so we can put a condition in a will. Let us say my child, after attaining 21 years or 25 years, till such time, he cannot use this. He cannot be a beneficiary. He cannot become a owner or
Okay.
something like that.
Okay.
Only after reaching a particular age,
Hmm.
you can, or else you can say after finishing the graduation,
Okay. Okay.
or else if daughter were to be there, after the marriage with so and so person.
Oh, that's specific also. Okay.
Possible. Sometimes it is possible, yeah.
Yeah.
Because it is my intention, no?
Yeah. Yeah. Okay.
That's very simple. That's
Hmm. So, in terms of liabilities, right, like a loan, do liabilities also get
yeah.
put into a will?
Yeah, we can. Say, assuming that there is a father has constructed a house.
Hmm.
There is a 1 crore, say about loan is there.
Hmm.
He is 50-year-old, let us.
Okay.
Now, anytime he may die, we don't know.
Hmm.
So what he says, I have cleared loan to the extent of 40 or 50%. Let us. Remaining 50%, so and so son will
Okay.
clear off the loan, and then Thereafter, he becomes the owner of the property.
Okay. Okay.
That sort of a condition can be put. Because he is giving the property, then the liability is also there.
Yeah.
Someone has to clear the liability. Otherwise, the banker will not leave.
So in case of joint property ownership, right? So let's say that I own a property with my husband. If let's say one person, one spouse dies, and there is no will. So does the second spouse automatically inherit the property?
No, it is not so. See, as far as the loan, taking the loan is, he or she may be a co-applicant. Now again, under what circumstances loan is granted, that needs to be looked into. If he or she were to be a co-applicant, then who is the guarantor? That also needs to be looked into. That is the one method of looking and repaying that and getting back that. As you said, in the absence of will, wife and children, all of them will become, they have equal rights on the property of the person who died.
Okay. Okay.
See, after clearing of the debts, they have to sit and talk about who should be the owner within the family.
Okay.
In the absence of will. Now, accordingly, they have to take a call. In the absence of will, you may have to go for a family tree in Karnataka. In family tree, wife's name and children's name will reflect. Accordingly, all of them have got the rights. The person who, let us say, wife, 2 children are major, let us say.
Okay.
Now, all the 3 have got equal rights.
Yeah.
Right?
Yeah.
Now, remaining 2 children, they have to give a release deed in favor of mother. That means, say, I am surrendering my right, okay, which I got due to intestate, right? That I am surrendering in favor of my mother. Okay. That is known as release deed. I will have to execute, the children have to execute a release deed in favor of mother. Thereby, mother becomes absolute owner of the property.
Okay. I see. Okay. But there are different kinds of property ownership also, right? Are there any kinds of property ownership where the right goes absolutely to the joint property holder?
Now, it all depends on how it is being drafted when you buy a property.
Okay.
Jointly owned means how it is owned, how much money is pumped by each person, what is the ratio of the ownership that they are maintaining. Everything has to be mentioned in the deed. Okay. Tenancy in common, probably, which you know. Tenancy in common will not give right to the wife directly. It will not give.
Okay.
So 99% of the property documents which are said to be joint, in reality they are not joint from the legal perspective.
Okay.
If it is tenancy in common, then all the children plus wife, they get the equal rights.
Okay. So in addition to tenancy in common, in addition to tenancy in common, what are the other 2 or 3 different types of property ownership?
Joint tenancy.
Okay.
So it's slightly technical for a beginner to understand or the common public. So better to discuss with professionals and take a call before buying any property.
Yeah. But there are 2 or 3 different types, and that will determine who will inherit the property in the case of the death of one of the property owners. Basically,
to avoid all these, to avoid all these problems, better the moment a person who buys a property, let him execute a will.
Got it. Of course. Yes. So also wanted to understand, so let's say that someone dies and only has bank accounts or fixed deposits, right? And in that case, if they just add a nominee, right? We add a nominee in all of these accounts, then that should be enough. That should suffice, right? Or do they still need a will?
Yeah. See, from general point of view, nominee gets the money, no doubt about it, because bank is discharged from their responsibility of giving the money to the nominee.
Okay.
Now, nominee by himself or herself will not become the owner of the entire money.
Hmm. Hmm.
He or she is only a custodian
Hmm.
or a trustee.
Hmm. Okay.
If he or she were to be one of the beneficiaries,
Hmm.
only to the extent of his or her share,
Mm-hmm.
she can keep. Remaining, she has to give it to the other legal heirs.
Okay. Okay.
That is the meaning of nominee.
So if somebody is not a beneficiary, they can still be a nominee.
Nominee can be a beneficiary, no doubt. I'll give an example. Now, my mother has a bank account, let us say.
Hmm.
Now, money is lying, let us say, 9 lakhs.
Hmm. Okay. Yeah.
She died intestate, let us say. She is
Okay.
no more in this world, so I'm taking the example.
Hmm.
So, she died. Now she made me as a nominee,
Hmm.
right? I take entire 9 lakhs.
Hmm.
So, I'm not the owner of to the extent of 9 lakhs. Assuming that I have one sister and one brother, okay, I can keep maximum to the extent of 3 lakhs.
Okay.
Remaining 6 lakhs, I'll have to give them equally to my sister and brother, 3 lakhs respectively.
Okay.
That's what the nominee role is all about.
Mm-hmm. And are there any tax implications of executing of inheriting a property?
No, in India, there is no inheritance tax at all.
Okay.
Zero.
Okay. Now let's say that I have some dependents who are either mentally or physically challenged, right?
Yeah.
How can I plan my estate and take care of them in those circumstances?
Okay. Normally, will may not be that useful here, excepting for appointing guardian.
Hmm.
That's a good thing. Guardian, and then it is always advisable to go to the family trust angle, which is there in
Okay.
the Indian Trust Act. Okay.
Okay. Okay.
So that we can give a ring fence or a protection to the special person.
Okay.
So it will be a different subject altogether. It has got
Yeah.
a lot of nuances and technical dimensions altogether.
Yeah.
So family trust can be established for the safety of a special person.
Okay. I see. Got it. Now,
That's
let's
all.
say there are NRIs and, a will needs to be executed. They are not here in the country. Do they need to be physically present to execute a will? And how
No,
does the
no.
whole
See,
process work? How long does it take after somebody has passed and they have a will? How long does the whole process take to transfer the assets?
uh, okay. Now succession laws of two different countries are different. It is not one and the same. They
Correct.
are country specific in nature,
Hmm, hmm.
right? Now it's better to execute two different wills. That will take care of many of the complexities of
Okay, two
whatever
different
law.
wills.
Let us
Okay.
say. Let me give an example. U.S. and India. Let us say
Hmm, hmm, hmm.
for U.S. properties, let him do whatever that according to their law, how it has to be done. For the
Hmm,
expats and everything would have been defined very clearly. For
hmm,
NRIs, it would have been defined very clear.
hmm,
Accordingly, let him do there.
hmm.
For Indian, as per the Indian requirement legal system, if it is done, then there will not be any problem as such.
Okay,
So
okay.
only exception is recently I did a program to UAE,
Hmm.
Abu Dhabi.
Okay,
There some laws have been amended,
okay,
which is known as civil law there.
okay.
Okay, for civil and personal law, there an expat can execute a will.
Hmm.
That will has to be translated into Arabic.
Oh,
Okay,
okay.
that they have to take it to a court there,
Hmm.
register that,
Hmm.
then it becomes a valid. Even Indian expat can execute there.
Okay, this is even for
That's it.
property
That
in India.
in India there also. He may would have accumulated there
There
also.
also.
In UAE
Yeah,
also.
yeah.
That's so. And the cost is not too much.
Okay, okay, okay.
See, when I did a program to UAE,
Hmm.
then one of the persons who followed the system beautifully explained everything.
Okay.
Then the cost of it also he told me. At that time it was 4,500 dirhams.
Hmm, hmm,
Not
hmm.
much.
Okay.
It's not based on the total value of the property as
Of the
such.
property. Okay.
That's all. See, country-specific laws need to be adhered to.
Yeah. Absolutely. Absolutely.
That's all.
So if the NRI is a beneficiary of in a will, do they have to be present here when the will is being executed or not?
No,
Not
no need,
required.
no
No
need,
need.
no need, no need, no need.
Only the executor has to be present locally.
No, at the time of execution, after the death of a person, at the time of execution, executive role comes into operation. That's
Yeah.
all. That's nothing else.
Okay. So thank you, Vijay. I think you gave us a lot of insights, lot of knowledge. I mean, lots more for me also to learn from this. So thank you for your time. Thank you for sharing all of this information with us. And any other closing thoughts? Any other last advice you would like to give us?
It's a big, this subject is a big ocean.
Yeah, true.
So it is better to take drop after drop,
Hmm.
understand that clearly, so that your prospects or clients, they are well educated and take an informed decision. That is very
Yes,
important. The
yes,
object is that now,
yes.
getting the awareness of it first.
Absolutely.
That's
That's
it.
our
If they
goal
come,
with the academy as well, just to educate people and to ensure that their interests are protected. They know all of the information before they take any decisions. So
yeah.
thank you. Great speaking to you, and maybe we'll do another
See,
session once again soon.
okay.
Yeah.
Bye,
Thank
sir.
you.
Thank you very much. Thank you.
Thank
Bye.
you. Thank you.
Thank you. Bye.